Hello friends, in this video I am going to discuss Insolvency and Bankruptcy Code. The Insolvency and Bankruptcy Code 2016, or simply IBC, is the bankruptcy law of India, legislated to consolidate the existing legal frameworks of making a single law for insolvency and bankruptcy. However, before understanding the provisions, first understand what is meaning of insolvency. Insolvency is a critical situation when an individual or a firm is unable to pay the money owed on time. The person or firm who is in a state of insolvency is said to be insolvent. Now, the question is, what is meaning of bankruptcy? Bankruptcy is a critical legal status of a person or other entity who is financially not capable to repay debts to creditors. Normally, the bankruptcy is imposed by a court order, which is initiated by the debtor. Now, the question is, what is meaning of creditor? Creditor means any person to whom a debt is owed and includes a financial creditor, an operational creditor, a secured creditor, an unsecured creditor, and a decree holder. Now the question is, what is meaning of financial creditor? Financial creditor means any person to whom a financial debt is owed and includes a person to whom such debt has been legally assigned or transferred to. Now, the next question is, what is meaning of operational creditor? Operational creditor means a person to whom an operational debt is owed and includes any person to whom such debt has been legally assigned or transferred. Now, the question is, what is meaning of debt? Debt means a liability or obligation in respect of a claim which is due from any person and includes a financial debt and operational debt. Now the question is, what is meaning of financial debt? Financial debt means a debt along with interest, if any, which is disbursed against the consideration for the time value of money. Now, the next question is, what is meaning of operational debt? Operational debt means a claim in respect of the provision of goods or services, including employment, or a debt in respect of the repayment of dues arising under any law for the time being in force and payable to the central government, any state government, or any local authority. Now, the question is, what is Insolvency and Bankruptcy Code? As defined in the Act, it is an act to consolidate and amend the laws relating to reorganization and insolvency resolution of corporate persons, partnership firms, and individuals in a time-bound manner for maximization of value of assets of such persons, to promote entrepreneurship, availability of credit, and balance the interests of all the stakeholders, including alteration in the order of priority of payment of government dues, and to establish an Insolvency and Bankruptcy Board of India, and for matters connected therewith or incidental thereto. Now, let us understand what is meaning of the definition. Following are the important points that we need to understand in order to understand the above discussed definition. It is the law created to consolidate and amend the existing law. It is related to insolvency resolution. It is applicable for company, partnership firms, and individuals. And Its aim is to resolve the dispute on time and promote entrepreneurship. Now, the next question is, who are the parties applicable for this provision? The provisions of this code are applicable to any company incorporated under the Companies Act 2013 or under any previous company law, any other company governed by any special act for the time being in force, except in so far as the said provisions are inconsistent with the provisions of such a special act. Any limited liability partnership incorporated under the Limited Liability Partnership Act 2008. Such other body incorporated under any law for the time being in force as the central government may, by notification, specify in this behalf, and partnership firms and individuals in relation to their insolvency, liquidation, voluntary liquidation, or bankruptcy as the case may be. Now, the question is, who can apply this provision? It can be applied by creditors, both financial and operational, debtors, authorized members, person in charge of managing the operations, and who has control and supervision of the debtor. Last but not the least, when can apply? It can be applied on payment default of a minimum of rupees 1 lakh or a central government prescribed amount up to rupees 1 crore, a statutory cross default for financial creditors. So, this is all about Insolvency and Bankruptcy Code.